Welcome, everyone. We've got a few people that are still logging in, but we're going to go ahead and get started so we are conscious of everybody's time. My name is Rebecca Wenglinski, and I'm the Director of Marketing and Business Development for Kerr Russell. We're excited to be here today to discuss the opportunities and obstacles that contractors may be facing right now. And we're going to start with just a few housekeeping items. So on the screen, you'll see some of these here. Everyone but the panelists will be muted for the entire presentation. If you have a question, there is a question panel that you can go ahead and submit that into. And we encourage you to do so because we do want to make this a little bit more conversational at the end, so that way we ensure that we are answering anything that may be pressing to you right now. A recording of this webinar along with the slides will be provided to all of the attendees next week. And we have three Kerr Russell attorneys with us here today to speak to you. Max Sneed assists clients with contract formation, negotiation, intellectual property, and entrepreneurial growth. Jason Bank assists clients with restructuring, reorganization, bankruptcy, and general business law. And Liam Healy helps clients maintain compliance with employment laws and employee benefits. At this time, I would like to go ahead and turn it over to Jim Chase for a few words. Jim?
I'm sorry. I'm sorry. I missed that. You got blocked out. I had another voice on there. Just want to take a second to welcome everyone. Thank you for tuning in with us today. I'm sure that this is going to be a terrific program. Max, Jason, and Liam will do a great job covering stuff like force majeure and how to deal with costs associated with social distancing, PPE, changing work schedules, and the like. I'm glad you tuned in. While I've got you here, I'd like to say that on Monday or Tuesday next week, you will be receiving an email from us advertising an educational program scheduled for June 18th on construction delay claims, which will be a good follow-up to this program. So hopefully we'll get a good turnout for that. And with that, once again, thank you for tuning in, and I'll send it back to Rebecca.
Great, thanks, Jim. Okay, at this time, I'm going to go ahead and turn it over to Max, and he is going to get us kicked off.
All right, thanks, Rebecca. This is Max Sneed. I'm an attorney at Kerr Russell & Weber, and I've been asked to talk a little bit about the challenges with contracts in the age of the coronavirus pandemic. As I'm sure we all know, executive orders and just the general difficulties of working in this environment has rendered some people unable, or in some cases unwilling, to perform under a previously negotiated and executed contract. So there are three basic arguments for getting out of a contract for a pandemic. One is a specific clause in a contract, often but not always called a force majeure clause. But even the absence of a specific contractual clause, the doctrine of impossibility can sometimes be invoked. And if the contract is for the supply of goods, Uniform Commercial Code does have a provision that is similar to a force majeure clause that's implied in all contracts for the sale of goods that can be used to argue for excused non-performance. So there are two sides to this. If you are a contractor who is unable to perform due to an executive order, but the other side of the contract wants you to perform, you may need to invoke a force majeure clause or invoke the doctrine of impossibility. But there's the other side of it too. If you have a subcontractor that is refusing to perform, can that subcontractor validly excuse his or her performance based on the coronavirus and the pandemic? And a lot of that depends on whether the performance is truly impossible and in many cases because of an executive order illegal, or is it just more difficult or more expensive or more dangerous? And in those cases, it's a lot harder to invoke an impossibility or force majeure clause. Next slide, please. Thank you. So obviously, we should start with the contract. Most sophisticated contracts will have a force majeure clause, but a lot of times people might just be dealing with a short little purchase order that doesn't have fulsome terms and conditions. But if there is a sophisticated contract, usually it will have a force majeure clause. Now that might not be called force majeure. It may be called something, just excused contract, some other phrase. But often force majeure is the wording to look for. And most likely the phraseology is out of the party's reasonable control. And that's a pretty broad term. But if there is some cause that renders performance impossible or renders timely performance impossible, often the performance will be excused. But again, the contract language varies greatly. There are so many different variations of a force majeure clause. You have to start with a contract, you have to read it carefully, and you have to obviously apply it to the specific situation. Next slide, please. So, does force majeure come into play with the COVID-19 pandemic? Again, looking at the specific language of the contract, some force majeure clauses have actually specifically called out a pandemic, or more commonly a public health emergency, as an event of force majeure. This gives somebody trying to invoke the force majeure clause a better argument. If it is called out specifically, then there's a pretty good argument that performance can be excused based on a force majeure. But such clauses, at least historically, have not been the norm. But we expect now that this pandemic's been going for a couple months, the contracts we're writing these days do have more specific language. And as a side note, contracts that are being written now are often being written with an exclusion so that the COVID-19 pandemic cannot be a cause of force majeure, because the parties know about it. They know what they're getting into. If they cannot perform in the age of a pandemic, then they shouldn't be signing the contract with their knowledge of the pandemic now being 2 months old. So more commonly than an actual call out of the pandemic as an event of force majeure, I'd say most force majeure clauses do reference governmental regulation or other state action as an event of force majeure. And so in those cases, it really is going to come down to, is the performance illegal now? Is there an executive order making performance illegal? And if so, if there is one of these governmental regulation or state action portions of the force majeure clause, there's a very good argument that performance can be excused because the force majeure event is called out specifically, made illegal by a government regulation, by an executive order. Most of the time, by invoking the force majeure clause, the party looking to excuse performance is just going to get a delay until the governmental regulation expires or is revoked. And assuming the other party still wants performance after a delay, performance will still have to be given. And even if the other side says, delay has been too long, I don't want performance anymore, obviously if no work has been done due to force majeure, any funds that have been given have to be returned. Next slide, please. So even if the force majeure is broad and just is basic and just says that performance will be excused if there is an event beyond the party's reasonable control and doesn't have any specifics such as governmental actions or executive orders or even health emergencies, the contract will have that catch-all, and pretty good argument that force majeure will still be applicable to a situation where performance, again, has been rendered impossible. But Courts typically strictly construe force majeure clauses. They don't want parties trying to get out of legitimate performance under the pretext of a force majeure. And so again, if performance has been rendered literally impossible or illegal, it's a pretty good argument. But if there's a situation where a subcontractor of yours doesn't want to perform, despite that it's performance that is exempted from an executive order, or is for critical work, or is for construction that as of May 7th in Michigan is permitted, but the subcontractor just doesn't want to do it because of fears of being too close to other people, that's a harder argument to make. That subcontractor will have a difficult time claiming force majeure. If they could do it, they just, it might be more challenging, might be more dangerous, might be more expensive, might be more difficult to find workers willing to do it. But in that situation, if the work is not illegal or violative of an executive order, probably the contract will have to be performed, or there'll have to be a negotiation of some sort of accommodation. Now, again, we need to look at the contract specifically, because just because there's a force majeure clause in there, and just because generally it applies, doesn't mean it's going to get a party excused from performance. And especially if the other party wrote the force majeure clause, there may be some pretty strict requirements under there. In fact, some are actually written to be unilateral, so only one party can invoke force majeure. If that's the case and you're not that party, you will have trouble invoking force majeure. We'll talk a little bit about some other options you may have under implied provisions. Most force majeure clauses do have a notice requirement. You can't just stop performance and claim it was because of the pandemic. You need to give notice. You need to have, usually a clause will require specific notice about when performance will cease, when performance will return, and it often gives the other party the option of canceling the contract or allowing performance to continue once the event of force majeure has gone away. And again, under most force majeure clauses, it's not enough that the contract just be difficult or more expensive or more dangerous. Usually, the pandemic must make performance impossible, which again, the easiest and most common way under this pandemic would be because of an executive order or other governmental regulation that makes performance impossible. So as we touched on before, if there is no force majeure clause, if it's a short contract, not a sophisticated contract, and this contract is silent, most states and most courts will adopt the doctrine of impossibility, which is essentially an implied force majeure clause. Be careful though, because a lot of contracts, especially if they're written in a one-sided way, will preclude somebody from using the impossibility doctrine. They may shift all risk of a pandemic or other emergency or other event of force majeure onto the other parties. So even under the doctrine of impossibility, if the parties have contracted that one party takes on all the risk, then impossibility will not be an option. Next slide, please. Some states have codified the doctrine of impossibility, and they reference a supervening impossibility. And again, if the contract specifically allocates risk to the other party, then the doctrine of impossibility, even under a code that has adopted it like California has, it will not be an option. Next slide, please. Thank you. And then the other possibility is if it's a contract for the supply of goods. The Uniform Commercial Code has essentially an implied term of force majeure. And if there is an unexpected contingency that rendered performance impracticable, in the words of the UCC, then performance can be excused at least during the period of time that performance was rendered impracticable. And again, under the UCC, parties can override this by contract language. So again, if the contract is written in a one-sided way, beware that there could be a provision in there that shifts all burdens of potential force majeure onto one of the parties, hopefully not you. Okay, next slide, please. So again, just reiterating what we've discussed, if a party's performance has truly been rendered impossible, it's likely the force majeure will excuse performance, at least temporarily, at least until such time that performance becomes possible under governmental orders. And again, the best argument for invoking a force majeure or impossibility defense is if there is an official government order that clearly precludes performance. This can get dicey. We have some of the executive orders in Michigan, there's been complaints that they are not as clear as they should be. And so what if one party thinks that performance is impossible and the other party says the executive order doesn't apply to this situation? Sometimes that can be unclear, and then the parties have to work it out and come up with the best arguments they can as to what is applicable, whether the force majeure clause applies to this situation and this particular work and this particular executive order. If you are in a position to be seeking to invoke a force majeure clause, you should give prompt notice, be as specific as you can, and keep the other party updated as to when performance will be possible. And again, check for the contract itself, make sure there's no shifting of the risk in the contract itself. If you're on the wrong side of that, then all of these doctrines, force majeure, impossibility, and the UCC will not help you because you have accepted the risk of an unforeseen event. So that's the end of my slides. I appreciate everybody's time, and if you have any questions, I'd be happy to answer them at the end of the presentations.
Thanks, Max.
Thanks.
My name is Jason Bank, and I am going to talk for 15 minutes or so on how to deal with businesses in financial distress and what to expect going forward, which is going to be a very tall order trying to tell you everything you need to know. So I'm going to try to keep it at a very kind of high level view and tell you some things to be thinking about and what I expect to happen as things play out over the next rest of 2020 and beyond. So I think the first thing, and this is probably nothing newsworthy for anybody here, but the economic impact of COVID-19, it's really resulted in just a sledgehammer to the economy. It's really grounded everything to a halt. False businesses have had to shut down or work remotely, and it's resulted in historic unemployment. Governmental loans, which will be talked about in a little bit by Liam, is only providing a temporary solution, and the health crisis is now just a full-fledged national economic crisis. So I'll be talking about sort of what's next, and a lot of the questions, of course, we don't have answers to, but I wanted to start with some good or some positive news. This is a situation where you have a compare things to how things were 10 years ago with the Great Recession, and I think that some positives are that the banks are in a much stronger position today than they were 10 years ago. You recall that we had bailouts and we had large organizations that were failing on a daily basis, and there was this notion that, boy, the economy's in trouble, and then the banks that we go to loan money to us, they're also in trouble. So how is this all going to play out? I think the automotive industry and the big three are in a much stronger position today. Now, obviously, they have their challenges. There's no doubt about that. But you recall that 10 years ago, GM and Chrysler had filed for bankruptcy. Pretty much every major supplier had to either go through bankruptcy or go through an out-of-court workout. And I believe that experience that the automotive industry had to go through has put them in a position to be much stronger today. And I think that they are much more adept to dealing with these pressures. I'm doing a number of some work in various automotive cases, and because of that experience 10 years ago, it's almost as if, well, we've seen this before, we can handle this, we just have to adapt. And then finally, I think that the housing market and the economy in general also was much stronger prior to the COVID-19 crisis, in 2008, there were a lot of signs of distress that were kind of flowing through. But in this sort of situation, we have, I think, a much stronger economy. And the hope would be that that would allow us to bounce back quicker. And of course, that'll remain to be seen on that. More positives very quickly here. This is not our first rodeo. I think for most people that are participating in the webinar today, they had to go through the Great Recession, and they had to make some of the tough decisions that many businesses are going to have to face on a go-forward basis. I think another big thing too is that there's this feeling this time around that we're kind of all in this together. There's no business, there's no person that has not been impacted by the shutdown or by the economic turbulence. And I think as a result of that, the creditors out there are going to be more willing to work with companies and work with business owners to find solutions. It's almost as if we have a national forbearance where creditors are not taking action to enforce rights and things that you see that really causes a lot of the economic distress and kind of forcing businesses to either reorganize or file bankruptcy. And in a way, it's providing businesses with a sort of a breathing spell, if you will, to sort of sit back, evaluate its business, think about how its business should function and can function in the new economy and the sort of the new normal that we refer to with COVID-19. Of course, I'm a bankruptcy lawyer, so I have to get to the bad news eventually, right? So these are some of the issues that I see from a business perspective. Of course, the PPP loans, only a temporary fix. It's not a long-term solution. One of the concerns, of course, is this is a seismic change in the economy. So many sectors of our economy are going to have to be fundamentally different. So many businesses are going to have to be fundamentally different going forward. As far as restaurants, movie theaters, and gyms and the like. I think that in past recessions, there was sort of a curve and an expectation that, hey, historically, things are going to come back in this order. Now I think that on a go-forward basis, the rebound and the pace of the rebound is very uncertain. And I think we're going to be in a situation where you're going to have a lot of businesses that are not going to survive. And then I refer to, and many others have referred to, sort of a tsunami of bankruptcies. And I use that analogy because I think that the tsunamis sometimes will come after an earthquake. And sometimes it's unknown when it's going to come and how bad it's going to be. And that's the case that we're in. The COVID-19 crisis is essentially the earthquake. And now we're waiting to see what's going to happen on a go-forward basis with bankruptcies and restructuring. So a lot of questions, and at this point, very few answers. But I'm going to do my best to kind of give you my thoughts on how I think things are going to necessarily play out. So an overview, I'm sure a lot of you have dealt with bankruptcy and restructuring or have been touched by it either, as your own business or as a creditor, obviously, in dealing with various things. So a bankruptcy, I always refer to it as another tool in the toolbox for a distressed business. It's a tool that you don't want to use if you don't need to, because there's obviously a lot of distress that is caused on a business if they have to go through a bankruptcy. It's a very expensive process. There's a lot of time and energy that a business owner has to divert away from doing what the business owner does best, obviously running its business. As a reminder, a Chapter 11 is the traditional reorganization part of the bankruptcy code, and that's where a business will file and seek bankruptcy relief to obtain a temporary stay of collection from various creditors, known as the automatic stay. The business owner generally remains in control and keeps operating as if the bankruptcy did not happen under the supervision of the court. And then the Chapter 11, the company in Chapter 11, the ultimate goal is to file a plan to restructure its obligations, to restructure its debt, and to ultimately potentially pursue a sale of assets through bankruptcy, but to try to come up with a plan and a solution to keep the business operating, to maybe stretch out payments to creditors, maybe eliminate debt, and have the company be a viable entity going forward. The Chapter 7 is a chapter of the bankruptcy code that a lot of individuals will file, but it's also a chapter that companies will file if they want to just simply liquidate their assets. So if a company believes that they're no longer a viable business entity, they can file Chapter 7. A third-party bankruptcy trustee will be appointed, and that trustee will essentially take over the affairs of the company in the wind down process, and they will oversee the liquidation of the assets. Bankruptcy, it's often used as a negotiating tool to restructure the out of court. What that basically means is that, as I said before, bankruptcy is a tool in the toolbox. You don't want to use it if you don't have to. I've used the analogy also before that bankruptcy and dealing with creditors is sometimes the gun that you have in the holster. You know, you want to kind of flash that gun around and say, you know, if I'm a business and a creditor is giving me issues, I could file a bankruptcy, which would impact the creditor's rights. But I would rather try to, negotiate something outside of court and avoid bankruptcy. And that's often done in the relationship and the dichotomy between a business and its lenders. You know, where a lender is potentially going to take adverse action against a business, they realize that a business could go into bankruptcy, which would be adverse to the lender, and so sometimes that will happen. One more comment about Chapter 11. The COVID-19 Act recently amended the bankruptcy laws to make it a little bit easier for small businesses to file bankruptcy. If you have debt of less than $7 million, you can go through a more streamlined process. That literally just went into effect in February prior to the enactment or prior to the COVID-19 crisis. So it's really kind of unknown at this point. There have been a lot of cases that have filed through the system to see if that's going to provide a benefit or not. So the big question, of course, is when will the wave of bankruptcies hit the shore? A lot of people have called me over the last few weeks and say, geez, JC, you must be really busy with all sorts of bankruptcy filings. And really the answer is no, not really. I mean, there have been a couple of cases that have filed. We'll talk about retail in a second. But for the most part, there have not been a lot of bankruptcies. And the reason for that is this national period of forbearance that I talked about earlier. Companies generally file for bankruptcy due to two primary reasons. And one is there's an imminent threat that may irreparably harm the business. So if a creditor or a bank gets a judgment and they're about ready to seize assets, or a bank that's your lender has declared a default, and they're going to sweep all the money from your bank account. That's the kind of action that generally will require a company to run to the bankruptcy court and prevent that from happening. And then from a long-term perspective, a company might file bankruptcy because they have concerns over the balance sheet. The debts exceed the assets, they're not able to sustain that, and they want to basically restructure that balance sheet through a plan. So right now, companies are not filing bankruptcy, again, because there's this national forbearance, no creditor pressure, and there's a lot of uncertainty over the future. So even if I wanted to formulate a plan, it's very difficult for a lot of us to be able to determine, okay, what are my revenues going to look like? What kind of costs am I going to have? Making sure my business is in compliance with COVID-19. So there are a lot of uncertainty there, and all those factors are the reason why we don't have bankruptcies that are taking place right now. The exception is retail, and I'm sure you've seen the news. The retail bankruptcy wave has already arrived. There's major retailers filing every day. And I think the reason for that is that these retailers, these traditional brick and mortar stores, were on the brink of bankruptcy prior to COVID-19, and some of them even went in. Art Van Furniture in Michigan, of course, a very well-known business, had the worst timing of any bankruptcy filing known to man, where they filed, I think, on March 8th, right before the crisis hit. And they essentially had to go into a liquidation mode because there was just no ability to recover. JCPenney is an interesting story. JCPenney, as of last evening, was preparing to file bankruptcy today, but apparently they worked out something with their lenders and made an interest payment, and they have sort of delayed the filing there. But every day you're going to see retailers that are going to file, and this is going to result in a significant impact, of course, on commercial real estate in general, and construction, because these retailers are going to probably be exiting locations. They're going to be rejecting leases. They're going to be getting out of these big spaces, and that's going to cause a tremendous amount of stress on the commercial real estate market, and of course the consumer market as well. So my crystal ball, where I get to sort of predict what will happen. I think that summer of 2020, there's going to be so much focus on returning to work, the new normal, as far as making sure our offices and our buildings and our places of work are in compliance with COVID-19 procedures. And I think banks are kind of in that same boat. there's still sort of this feeling that we're sort of all in this together. I think that fall 2020 is when the banks and lenders are going to start to return to sort of their normal practices, where they're going to have to do their jobs as bankers, where if a company is, missed a payment or is in default of various loan covenants, banks are going to have to start, taking some action. And one of the things I think you're going to see is forbearance agreements. And the forbearance agreements is essentially an agreement where you sort of kick the can down the road with strings attached that says, all right, you will have X number of months or weeks to sort of right the ship. And if you don't do that, then certain bad things will happen. So forbearance agreements will be executed, which will keep things out of court. And then I think when we can talk about when will this wave occur, I think it'll fall 2020, winter, spring 2021. The creditors are going to start exerting some more pressure. You're going to have more businesses that will file. I think other businesses will just sort of throw up their hands and say, we don't see a viable strategy going forward, and they're going to liquidate. And then also one of the things as well, this has been a tremendous hit on unemployment, of course, is raised. And I think there's going to be a wave of consumer bankruptcy filings as well, probably 3 to 6 months down the road. So very briefly, here are some tips for every business. And this is some basic stuff for a lot of you, but I think it's all worthwhile going through. It's critical to conserve cash. If you do have a credit line that you can tap into, trying to obtain cash and conserve cash is key. Minimizing expenses, restructuring liabilities, anything you can do there. And then sales of non-critical assets. If you have things that you don't need for the business and you're able to sell, to bring in cash, that's a good thing. And then finally, communicating with your lenders and creditors is going to be so critical in all of this, is to basically continue to talk to them. And my experience, especially with work with bankers, is you keep talking to them, you give them the understanding, then they have less of an issue. Tips for creditors, and again, this might be basic stuff as well, but tighten and limit credit terms. Cash on demand is always a good thing. I always say at the end there, don't worry about bankruptcy preferences, get the money. A cash on demand payment cannot be a preference. If you're getting the money as you provide the product or the service, it cannot be a preference. There's always the issue, of course, if you're borrowing money on a credit line and part of your formula for borrowing is receivables, and you're taking money as COD and you're letting your receivables get more than 90 days, you could have an issue there. But generally, I always tell everybody, don't worry about people filing bankruptcy, just get the money. So the silver lining, just to conclude my remarks, and I like this phrase and I use it often with my clients, whenever there's adversity, there's also opportunity. There's innovation, there's new opportunities. The decreased competition, I remember early in my career, I asked a client, aren't you concerned about your sector of business? And he said, no, I think this is great because a lot of my competitors who I don't think should be in this business won't be able to survive, and I'll be able to get more market share from that. So there's a notion that this provides an opportunity for leaner and meaner businesses that can use this sort of this restructuring, if you will, of the entire economy to basically grow and innovate their businesses. So I appreciate your time. I'm going to turn it over to Liam Healy.
Thank you, Jason. I'm Liam Healy. I'm an attorney with Kerr Russell, and I'm going to talk a little bit about the Paycheck Protection Program, kind of some basics in regard to the program, and then how to avoid problems and achieve maximum loan forgiveness, what steps you can take to do so. Next slide, please. So, of course, the Paycheck Protection Program was brought into existence by the CARES Act. And the CARES Act, effective April 1, amended the Small Business Act, specifically Section 7A, which was a provision that contained the basic provisions for many small business loans. And so the Paycheck Protection Program was added to the Small Business Act as an available loan. And essentially what it does is it opens eligibility. Typically under 7A, you had to be a quote unquote small business concern, and you had to fit within certain criteria, either relating to your industry or otherwise. And so one of the things that PPP does is it opens that up to other employers that might otherwise not be eligible. And one of the main criteria is that so long as you employ less than 500 employees, you will likely be eligible. There's some affiliation rules that we'll talk about a little bit later, and there's also some other tests and waivers that apply depending on your industry, which we'll talk about. But essentially, again, if you have less than 500 employees, you will likely be eligible for a PPP loan. The electrical industry is one that is based on annual revenue, and so you may otherwise be eligible regardless of your employee count. Next slide. So what are some of the basic requirements of PPP? There's a window for application. As Jason mentioned, this is a temporary fix. And so you have to essentially at this point apply by June 30th. The maximum amount of the loan is the lesser of 10 million or 2.5 times your average monthly payroll. Talk about what that means. You must have been in business on February 15th. You can't start a business today and immediately apply for a PPP loan. And there are certain certifications, and of course these have received a lot of attention in recent weeks. In the beginning, it seemed as though it was a pretty low bar for application as long as you saw some trouble on the horizon. Given the pandemic and you met the size requirements, it was there, and it seemed as though there was encouragement that you take the loan money in order to help your employees. But the application contains a certification, and essentially you're saying not only is there uncertainty, but I believe that this is going to affect my operations. You must certify in the application that you're going to use the money as intended. And so, if you have other money set aside and you never intended to use this PPP money for the intended purposes, you may have problems if, in retrospect, it looks that way to the agencies. And there is a fraud acknowledgement in the application. Essentially where you are saying, I understand that I'm making certain certifications here, and I can't mislead on this application. And then you must certify that you're a small employer. So taking into account the affiliation rules, you can't close your eyes to that. Next slide, please. So what is the qualified use? This is essentially the spirit of the CARES Act and PPP is that you're supporting your employees. And so essentially payroll costs, and we'll talk about what that means, is kind of the primary component. But in addition to that, you, as the applicant employer, can spend a portion of the PPP proceeds on other costs, but they're fairly limited. So you can service interest on a mortgage so long as it was in existence on February 15th, 2020. So again, you can't start a business, go take a mortgage, and apply for PPP to service that cost. Same for rent. As long as the lease was in existence at the beginning of the period, then you can spend a certain portion of PPP proceeds on your rent. And utilities, same rule. So payroll costs do consist of what you would intuitively believe, salary, wages, compensation. However, there's a cap. So you can only consider the first $100,000 of any employee's salary in both the application for purposes of determining your maximum loan amount, and also for how you use the money on the back end in terms of determining the threshold of loan forgiveness. We'll talk more about that in a moment. But salary or payroll costs do include other components such as vacation, family, medical leave pay. Now, if you are providing paid leave pursuant to FGRA under the Paid Leave Act or otherwise, you can't both take a credit for those amounts paid under FGRA and then also use PPP loan money to pay those amounts, because effectively you're getting a double tax benefit. And so that is one thing to keep in mind. But otherwise, what would otherwise be part of payroll costs are qualified uses for PPP money, including group health plan insurance premiums and retirement benefits, state and local taxes, and the associated taxes, employee portion of FICA. The only exclusion to that is the employer portion of FICA is not part of the equation here. So as of June 30th, your loan could become a grant if you used the money appropriately and you maintained your staff and you didn't cut salary beyond a certain threshold. But there is a formula in the statute. And so as of June 30, when you apply to your lender for forgiveness of your PPP loan, there are potential reductions. One of them is a reduction in staff. And so there's essentially a formula. You look at your staff as of June 30 versus your staff in prior periods, and if there was a significant reduction, then you're going to suffer a reduction of possible loan forgiveness. Now, there is a cure period, a cure provision in the CARES Act, which essentially says that if your staff is restored as of June 30th, then there's not going to be a reduction. And the problem with that is that you still have to meet the use requirement. So it's not a magic bullet where you can spend money on other things or hold the money and then as of June 30th rehire everyone and have the loan forgiven. So if you wait till the last minute to rehire your staff, you're not going to have met the payroll cost component of the loan forgiveness provision. So this is essentially the formula for determining what portion of the loan forgiveness will be reduced if you do cut staff, and it's somewhat intuitive. I mean, you essentially take the loan amount and multiply it by a fraction, the numerator of which is your current staff as of the date that you apply for forgiveness. The one twist is that you have an option as the employer in terms of what period you look at for the denominator of the fraction. So you can either look back in 2019 or you can take census information or data from earlier in 2020. And you simply have to do the analysis to determine what's more beneficial. And the lesser number is going to result in a lesser loan forgiveness. Next. So this is just an example that points that out. And again, it's fairly intuitive. ABC Electric borrows $1 million, and they employ 150 workers at the end of the covered period, quote unquote, which is the 8-week period after loan disbursement. And they employed 250 workers in 2019, but 200 in early 2020. And so you do the math, and the better option is period 2, which results in total loan forgiveness of 3/4 of the loan. So again, fairly intuitive there. Next. So there is a provision made by the CARES Act, which essentially says that, again, if your workforce is restored by June 30th, you're okay, and that would apply in the above example, and we touched on that before. Next. So you have to be careful about using PPP monies for other use. The the Treasury, although not specified directly in the Act, subsequent guidance by the Treasury says that you can't use more than 25% of the forgiveness amount for other than payroll. So if you're using all of the money for other reasons, such as the mortgage interest or otherwise, then that threshold is going to be taxable. I mean, there are some that believe that it's an all or nothing scenario. So, for example, if you haven't used all of the money by June 30th, you use half the money for the intended purpose, all of that portion should be forgiven, but not otherwise. And so, you borrow $1 million, you use $500,000 for payroll and other qualified expenses, 75%, 25%, but you still hold $500,000 at June 30th. There are some that believe that none of that is forgiven. We do not believe that that was intended by the Act. We think that there's more forgiveness. And so it's more likely that if you exceed, for example, if you spend all the money, but you exceed the 25% by some threshold, that's going to be the portion that's going to be subject to repayment. There are additional questions as to what are the specific timing requirements. Can you use the money for payroll, but for prior obligations that were incurred in advance of the covered period? Fringe benefit obligations, for example. Can you be delinquent on your fringe obligations, make payment out of PPP money in the covered period, but for payroll incurred in a period before, and still be using the money for qualified use? And there really isn't guidance on that at this point. Now, the definition of payroll is pretty broad, and so it would include those amounts. So if you make contributions to a fringe fund, those costs are usually covered by payroll. The question is, does the literal language in the statute, which says incurred and paid, really mean that? And so we're awaiting guidance. It's worth mentioning that we're expecting regulations any day. As of Wednesday, they were saying you're going to receive something in the next day or two. And so they may be issued today, and we may have much more information on this point. And so, this is the guidance to date, but there certainly is more to come on that issue of forgiveness. Now, affiliation rules is another issue. And again, you have to certify in your application that you are a small employer. So what does that mean? Now, the Small Business Act has detailed affiliation rules for purposes of SBA generally, and meeting the definition of a small business concern, quote unquote. And this predates the 500 employee limit with the PPP, because again, the SBA had employee headcount limits for various purposes. So the affiliation rules are quite detailed. And in the CARES Act, it was applied quite broadly, and it looked like from that vantage point that all of the affiliation rules would apply. Then there was subsequent guidance which narrowed the application of those rules. And so first it was, well, it's not 103, it's 301F, and there's 6 factors. But in those factors was a test which looked at facts and circumstances. So even if you didn't have control via stock ownership or one of the other factors we'll talk about, there was still the ability of the SBA to come in and say, no, you had an affiliate, you were much larger than 500 employees. Subsequent to that, there were FAQs that said, well, what we really meant by 301F was 4 out of the 6 rules. So the affiliation rules continue to narrow. Next. And essentially at this point they are this, And some of them are pretty familiar. You've got an ownership test. If one company owns more than 50% of the voting, equity, or otherwise of the applicant, then that second company has to be taken into consideration for the 500 employee test. There's also this concept of negative control. So if you have a shareholder that has, through the bylaws or otherwise, the ability to block action on the part of the applicant, you have a powerful shareholder. Even if they're not a majority owner, then there may be an affiliation where you have to consider other employees. Stock options and agreements to merge are also one of the factors. So if you're midstream in a merger agreement, or there's certain stock options out there, you have to consider those things when you're making the certification. And the SBA has been clear on that. Management, if you have if one company's managers or board has significant management control of the applicant company, then you may have an affiliation scenario. Identity of interest is less of a factor here. In the larger rules, it's considered on a business basis, but now it's really just a question of family members. Do related family have similar businesses, or is there a geographic area where there's a significant business, and you're looking at things kind of on a family business level. Next slide, please. So recent guidance, and again, this guidance is changing every day. So even since I submitted these slides, there has been further guidance in terms of FAQs for the PPP program. So kind of the first piece was question 31 in the FAQs, and anyone that applied for a PPP or is considering it should read through these FAQs, and they are updated daily. Question 31 was kind of a wake-up call, and it said, you have to look at this issue of whether or not you actually need this money. And one thing that I should have mentioned earlier is that a waiver within the CARES Act said, as an applicant, you don't need to tell us that you cannot obtain financing from some other source, which is generally a requirement with the other SBA loans. So that was waived initially, but then you had these news reports of large organizations taking PPP money, and the Treasury said, and SBA said, wait a minute, okay, did we really mean that? Well, you have to consider whether or not you can really, in good faith, take this loan, and you have to look at possible funding sources from otherwise. So question 31 deals with essentially public organizations, but quickly it was clear that this also applied to private organizations. In other words, yes, a public organization has access to funding elsewhere, but if you look at private organization that is also has great access to funding, you're probably going to have the same considerations. So that had people thinking about whether or not they should have taken that loan. Now, the SBA then came in and said, and Treasury said, well, if you took the loan and you're not sure whether you should have taken the loan, you can give it back. And the original date was May 7th. That was then extended to May 14th. And in the last day or so, it's been further extended to May 18th. So this is essentially, an ability to come clean, give the money back, and we'll consider the application in the first place to have been made in good faith. Guidance is changing quickly on this, and everybody understands that. So there's an opportunity to cure by giving it back. Then comes FAQ 46. Which says essentially that any company of under $2 million that took a loan for less than $2 million, we're going to assume that, generally speaking, you have less access to other sources of funding. So the review of these loans after the fact, anyone that takes a loan under that threshold is going to be deemed to have made the application in good faith, which provides some comfort, certainly, and is one of the latest developments here. Next slide, please. So I'm not sure that is the silver bullet. you know, it's still a question, and there's kind of two parts to this. One is, did you make the loan in good faith, and will there be ramifications if you did not? The second part is, of course, the loan forgiveness piece, and so we're going to see much more on that, maybe today, maybe early next week, but we're anxiously awaiting that guidance. So, to avoid problems, which is really the theme here, the loan application should be reviewed, and each of those certifications should be scrutinized. Certainly, if you've taken a loan and you're under that 2 million threshold, then there's some comfort there. But again, be careful. Document each stage of the transaction. Carefully consider each element of certification. Avoid internal documents and emails that make light of this money. Consider alternate financing. Document all of your expenditures. Segregate the funds. Money should be fungible, but you're telling the SBA that there wasn't other money. And so it's not a bad idea to segregate these funds. Be mindful of expenditures after the PPP loan. Don't do anything extravagant. I'm reminded of the gangster movies where the bank robber shows up with the new car and with his wife wearing the fur coat and the diamond ring. I mean, you have to be mindful of the optics of this. Now, one recent FAQ is, what if people don't come back? Is my loan going to be forgiven to the same extent given the headcount issue? If people don't want to come back, document that you made the offer, work's available, they wouldn't come back, and you won't be penalized for that. Don't borrow more than you need. And assume that this is going to be scrutinized. Build a file, be ready to defend your use of this money and all of the certifications, and use the money for what it was intended for. Thank you.
All right, thanks, Liam and Jason and Max. So we're going to see if there are any questions. I don't believe any questions have been sent in. So we have a few minutes left. If anybody would like to go ahead and raise your hand, it's over by where you can mute and unmute yourself. We can go ahead, and if there are any questions, I can unmute you and you can just ask it now. Wait a minute to see if any come in. All right. If there are not any questions, then as I said, we will provide the recording and the slides for this presentation next week. And we thank everybody for joining us and being able to speak with you today. Have a good day, everyone.